Sir, can you tell me your name, please?
Gabriel Barrows Leon.
Okay. And which case are you calling in on?
Oh, it's a CSD case and
He's at 245. 245.
Oh, okay. Hold on one second. I see. Okay, sir, your hearing's set for 2:45. So if you want to disconnect and call back in at 2:45.
I'm on the West Coast.
Okay. Yeah, it's set for 2:45 Eastern time.
Right, which would be I'm an hour early. I'm sorry.
Yep, that's okay. No problem. If you want to just sign back in at 2:45 or a couple minutes prior to that, our time.
Okay, sure will. All right.
Okay, sounds
All
good.
right.
Okay, everybody connected, so we'll go on the record in Cruz versus Cruz, file number 2319351. If I could have counsel put your appearances on, please.
Good afternoon, Judge Elliott Blumberg on behalf of the plaintiff, Danny Cruz.
Good afternoon, Your Honor. Chris Kolumchek on behalf of the defendant, and I do have laryngitis today. I'm sorry.
Okay. All right. This is set. I know we've been dealing with this case, Mr. Blumberg. I believe, if I recall correctly, you were having difficulties contacting your client. We're trying to get the judgment entered here. Mr. Blumberg, can you give me any updates on where things are at from your side?
Yes, Judge. I received a proposed judgment from opposing counsel or his legal assistant some time ago. I had responded in an email. There's just a number of provisions within this judgment that were never discussed and certainly never agreed to. So the judgment also references a uniform spousal support order, which has never been provided to me. So the judgment that I have does not comply with the terms of the mediation agreement, and it doesn't, it contains provisions that the parties never agreed to.
Judge, with regards to that, first of all, we're the defendant. We've been waiting for months now for the plaintiff to produce a proposed judgment. So we started the ball rolling by doing what we did. With regards to the uniform support order, he's supposed to produce that since he's the plaintiff and include it with the judgment. But that's going to be a uniform order. There's no reason not to sign the judgment. We all know what the uniform support order looks like. So we did this back in June 16th. We gave a proposed judgment after waiting week after week after week for one from them. And I have no idea what's going on or why this is taking so long. They never responded since June 16th, other than to say he would check with his client.
That's not correct. But Judge, if you want, we can go through this judgment and we can talk about all of the provisions that were never discussed, and certainly the ones that never were agreed to, including a mandatory arbitration provision. I don't know where they came up with that. It's never been discussed. And it's inconsistent with the provision that talks about this court having continued jurisdiction. I mean, there's just places in here that they just put in whatever they wanted. And I'm certainly prepared to either have a hearing on that, an evidentiary hearing, or we can go through it provision by provision, because it's just totally inappropriate.
Well, why are you waiting till now to say it for the first time? And with regards to the arbitrary, the arbitration, mandatory arbitration, that's for personal effects. And we do that all the time when they go to mediation so that they're not fighting over, hairbrushes in court. Now, all you have to do is strike it, and we would have said fine. But that's something that we put in our divorce judgments routinely. But to say it's somehow not purporting to what we've all agreed to is ridiculous.
You go to mediation, not binding arbitration.
No, that's just for personal. All right, strike it. We have no objection. If you're willing to sign it right now, strike that. Is there anything else you'd like to strike?
Yeah, there is.
Here, I'm gonna put, hold on a second. This is what I'm gonna do. I'm gonna put counsel into a breakout room. I'm gonna let the two of you hash this out. There's no reason why I need to listen to it or for it to be on the record. And then let's bring you back in, and if there are provisions that we can agree to, or if you guys can hammer this out now, I mean, I think everybody acknowledges that we need to get this done, and I don't know. I haven't seen any, what the proposals are. So I'm going to put counsel into a breakout room. I'm going to let the two of you see if you can hash this out. And if you can't, then we'll have to figure out where we go from there.
Judge, so you know, we did submit a copy of the proposed judgment in our motion to enter judgment. Because we have a motion pending today, motion to enter judgment at the same time as the status conference. And we have a proposed judgment there. Yeah, okay.
No, and I looked at that, but from my standpoint, I don't know what the agreements are between the parties, so I don't have anything to compare your judgment to know whether or not it comports with the agreement or not.
That's fine,
So
Your Honor.
that,
I'm sure we can hammer it out right now. It shouldn't take very long.
all right, so I'm gonna put counsel into a breakout room, along with, the clients, and let's see where we go from there. So just 1 second.
Hello,
Yes, can you tell me your name, please, sir?
Francis Earl Curtis, Jr.
Okay, Mr. Curtis, I have your hearing set for 2:30, so you can either disconnect and sign back in, or I can just put you in the waiting room until then.
I'll just go in the waiting room, sir.
Okay, thank you.
Yep, you have a good day.
Thanks. Okay, we'll go on the record in McDonald versus McDonald.
Thank you,
And
Your
this
Honor.
is
Miranda. Sorry.
So file number 2520075. Go ahead, Ms. Bailey, quick.
Thank you, Miranda Bailey Quick on behalf of Terrence McDonald. And he is present with me.
Thank you. And Ms. McDonald, if you can unmute, please.
Yes, Your Honor.
Okay, thank you. So we have Ms. McDonald present. Ms. Bailey Quick, I'm in receipt of a proposed consent judgment of divorce. Is that how you wanted to proceed today?
Yes, Your Honor. Thank you.
And Ms. McDonald, is that how you wanted to proceed as well? Ms. McDonald, I just need you to. There we go.
For a moment.
Okay. Did you want to proceed with finalizing the divorce today as well?
Yes, Your Honor.
Okay, so if I could have both of you please raise your right hands. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. You can both lower your hands. And Ms. Bailey Quick, if you'd like to proceed with the questioning of your client, please.
Yes, thank you. Terry, would you please state your name and spell your last name for the record?
Yes, Terrence McDonald, Terrence, McDonald, McDonnell.
Thank you. And at the time you filed your complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
I have.
And at that same time, had you been a resident of Otsego County for at least 10 days?
I have.
Were you and Miss McDonald married in Six Lake, Macomb County, Michigan on June 11th, 2019 by a person authorized to perform marriages?
We were.
And by information and belief, do you know whether Miss McDonald is currently pregnant?
No.
You do not have any minor children born of the marriage, either natural or adopted, correct?
Correct.
Right. At the time you filed your complaint for divorce, you had alleged that there was a breakdown of the marital relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at that time?
Yes,
And does that remain true today?
it is.
You got an opportunity to review the proposed judgment of divorce and you electronically signed that. Is that correct?
Correct.
And in that judgment of divorce, in essence, you keep what you have in your possession and Miss McDonald keeps what she has in her possession. Is that correct?
Correct.
There is a jointly titled and jointly financed vehicle that pursuant to the judgment, Miss McDonald has 60 days to refinance in her name. Otherwise, it will be awarded to you for you to sell and remove the liability for both of you. Is that correct?
Correct.
In the judgment, it provides that there will be no spousal support paid by either you or Miss McDonald to the other party. And you understand that after entry of the judgment of divorce today, that is forever barred. You can't come back to the court and ask for that, nor can Miss McDonald.
Correct.
Are you asking the court to enter the judgment of divorce today?
I am.
All right. I don't have anything further for Mr. McDonald.
Thank you. Ms. McDonald, are you currently pregnant?
No, I'm not.
And you understand that you're not going to receive any alimony or spousal support as part of this divorce?
That is correct.
You understand that you would be waiving that forever and that you can't come back later and ask the court for that?
Yes, I do understand, Your Honor.
Did you hear all of the questions that Ms. Bailey Quick had for Mr. McDonald and his answers?
Yes, I did, sir.
Do you have any reason to believe any of the answers that he gave were untrue?
No, Your Honor.
All right, and it looks like you signed the judgment of divorce in this case. Did you review that judgment before you signed it?
Yes, I did, Your Honor.
And by signing that, does that indicate your agreement with that judgment and your willingness to abide by that?
Yes, Your Honor.
Okay, thank you. Ms. Bailey Quick, did you have any questions for Ms. McDonald?
Just one follow-up. Ms. McDonald, you electronically signed the judgment of divorce, correct?
That is correct.
All right, and you acknowledge that that electronic signature is in fact your own?
Yes.
Okay, I don't have anything further. Thank you.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. I've signed that judgment with today's date. So the divorce is final as of today. Ms. McDonald, did you have any questions at all?
No, Your Honor.
Ms. Bailey Quick, anything further we need to address for your side?
No, Your Honor, thank you.
Okay, thank you. That's all for today, and both sides are free to disconnect.
Thank you.
Hey, Wendy, can you call the court and let them know that we're ready to come back in? It's Judge Mertz's case.
Okay, Mr. Blumberg, we're good. Okay, hold on one second. Okay, we're back on the record in the cruise matter. Mr. Blumberger, Mr. Podrick, were we able to reach any agreements?
Yeah, Judge, I think we are. I don't know if, I guess what's being requested of you is you have a copy of the proposed judgment in front of you?
I do.
Okay, so some of these provisions are going to be crossed out in total, and there's going to be some revisions made to others. So do you want to go through page by page?
Can we make a record of it, and then since you're plaintiff's counsel, or, well, I don't know, however you want it, whoever, Mr. Klondike already went through the time of drafting the judgment, whoever would be easier, but what I'd like to do, I guess, is make a record of it, have everybody agree to it here, to the language, and then have one of the counsel submit a clean copy for the court to sign.
Okay, well, Judge, let me, if you would turn to page 2 of the proposed judgment.
Okay.
We're under the provision of uniform spousal support order. It references the attached uniform spousal support order. We both acknowledge that hasn't been prepared, and I will be preparing that for the court.
Okay. Mr. Klondike, is that correct?
Yes, Your Honor.
Okay.
The next real changes appear on page 5.
Okay.
The provision under escrow accounts going to be omitted.
Is that correct, Mr. Klondike?
Yes, actually, the whole page is stricken.
That's right. The entirety
Okay.
of the arbitration clause is removed as well.
Okay.
Page 6 is fine in its current form. Page 7, we didn't really discuss in detail, and I need to talk to counsel about language that he put in there that, again, were never really discussed. And candidly, some of it may be accurate and some may not, but that page of the judgment is, from our perspective, not ready to be entered by the court.
Okay.
On page 8, there's going to be a revision to the provision that the paragraph that says, for purposes of qualifying the defendant, the member and former spouse acknowledged that they have been married for a period of more than 10 years, during which time the member performed more than, that should read, 7 years of credible military service.
Mr. Klondike, is that correct?
Yes, Your Honor.
Okay.
And frankly, Judge, the remainder of the judgment's fine in its current form.
All right, Mr. Klondike, is that correct?
Yes, Your Honor.
Okay, so here's how we'll proceed. I would like to have a clean copy prepared with regard to the language on page 7 regarding the military pension. Within 30 days, if counsel are not able to agree on the language under military pension, then I'm going to ask each counsel to submit in writing their proposed language for that. We're not going to schedule any further hearings. The court will, if there isn't an agreement and each counsel submits their proposed language for that, the court will adopt the language it finds most closely comports with the mediation agreement. I did look through the file. I do have a copy of the mediation agreement in the file. So I'll be able to make that determination. And then the court will enter a final judgment in this case within the next 30 days. Again, if there's an agreement, the court will enter it based on what the parties, the clean copy that's submitted. If there's not, then the court will, again, make its determination. The only thing now, since we've been on the record, everybody's reviewed it. We've got the agreements on the record that have been made with regard to the language here today. So in my view, the only thing that the court would consider any kind of further debate on is that language under military pension on page 7. And again, the parties, if they can't agree, will need to submit written proposals for that language. The court will make that decision without further hearing based solely on the mediation agreement and the submitted language. And then again, the court will enter that judgment within the next 30 days. Mr. Blumberg, do you have any questions or issues with that process?
Not that, Your Honor, but does the court records reflect that we took the proofs in this case? Because we're prepared to do that.
We did take the proofs.
Okay, thank you.
So really, it's just a matter of entering the language, the judgment. So, Mr. Klumjack, do you have any objection to that process to get this finalized?
No, Your Honor, none.
Okay. All right, thank you. That's all for today then. All parties are free to disconnect at this time.
Thank you, Judge.
Thank you.
Okay, Ms. Robinson, it looks like I'm got the other party's counsel here connecting in. Okay. Good. It looks like we have everybody present, so we'll go on the record in Skinner versus Skinner. This is file number 2520071. If I could have both counsel put your appearances on, please.
Good afternoon, Your Honor. Brooke Robinson appearing on behalf of the plaintiff, Austin Skinner, who is seated to my left, and we're both appearing via Zoom.
Good afternoon, Your Honor. Maria Zugraffi, PA3994, on behalf of Alba Otsego Skinner, who is present via Zoom today.
All right. I have this set as a date to take proofs and enter a judgment of divorce in this case. Ms. Robinson, is that how you wanted to proceed?
Yes, Your Honor, please.
Ms. Zagrafi, is that how you wanted to proceed as well?
That is correct, Your Honor.
Okay. If I could have both your clients raise your right hand, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Great, thank you. You can lower your hands. Ms. Robinson, you can go first if you'd like, please, with taking testimony from your client.
Thank you, Your Honor. Mr. Skinner, please state your full name for the record.
Austin Allen Skinner.
Are you the plaintiff in this divorce action filed in Otsego County Circuit Court?
Yes.
Did you file this case on May 7th, 2025?
Yes.
Were you and the defendant married on September 7th, 2024 in Gaylord, Michigan?
Yes.
Had you lived in the state of Michigan for at least 180 days and in Otsego County for at least 10 days prior to the filing of the complaint?
Yes.
Has the marriage broken down to the point that there is no reasonable likelihood that it can be preserved?
Yes.
Were there any minor children born or adopted during the marriage?
No.
Have you and defendant acquired any property or debts during the marriage?
Yes.
Do you have an agreement regarding the division of that property and debt?
Yes.
Does this agreement fairly and equitably divide your marital property?
Yes.
Are you asking the court to incorporate the agreement into your judgment of divorce?
Yes.
Are you asking for spousal support or alimony from the defendant?
No.
Do you realize that if you waive spousal support today, you cannot come back and petition the court for spousal support in the future?
Yes.
Have you signed the proposed judgment of divorce reflecting the terms of the agreement?
Yes.
Are you asking the court to enter this judgment of divorce today?
I am.
Your Honor, based on testimony, I ask the court grant a judgment of divorce incorporating the terms stated on the record, or incorporating the terms and contained in the proposed judgment signed by the plaintiff.
Thank you. Ms. Zagrafi, did you have any questions for Mr. Skinner?
No, Your Honor.
And Ms. Zagrafi, did you wish to take any testimony from your client?
Oh, yes, Your Honor.
Okay, please proceed.
Miss Otsego Skinner, can you please state your name for the record?
Alba Otsego Skinner.
Have you been a resident of the state of Michigan for at least 180 days and for the county of Otsego for at least 10 days?
Yes.
Are you in receipt of Mr. Skinner's complaint for divorce?
Yes.
Are you currently pregnant?
No.
Were there any children of this marriage?
No.
Have you reached an agreement on the distribution of property and debts between you and Mr. Skinner?
Yes.
Does that agreement fairly distribute your jointly assets and debts?
Yes.
Okay, and would you agree with me that this marriage has been irretrievably broken and there is no likelihood of reconciliation between the two of you?
Yes.
Okay, no further questions, Your Honor.
Thank you. Ms. Robinson, did you have any questions for Ms. Skinner?
No, Your Honor.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. I've reviewed the proposed judgment and find that it is generally equitable and contains all the provisions required by statute. Court will grant the divorce and sign the judgment with today's date. So the divorce will be final as of today. Ms. Robinson, is there anything else that I can address for your side for the record today?
No, Your Honor, thank you.
Ms. O'Graphy?
No, Your Honor, thank you.
Okay, thank you. That's all for this hearing today. All parties are free to disconnect at this time.
Thank you.
Thank you so much.
have the Curtis file.
You sure can.
Hello?
Hello, Mr. Curtis, are you there?
Yes, I am.
Can't see, there we go, okay. All right, we'll go on the record in Curtis versus Curtis. This is file number 2520094. The record should reflect that Mr. Curtis is present today by Zoom video. This hearing was set for 2:30. It is now 2:37. Ms. Curtis has not appeared. Mr. Curtis, I have this set for entry of a judgment of divorce today. Is that how you wanted to proceed?
Yes, sir.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Curtis, I'm going to be asking you some questions. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law.
Okay.
My first question, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes, it is, sir.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
Had you been a resident of Otsego County for at least 10 days?
Yes, sir.
In the complaint, there's a statement that indicates that there's been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Yes, it is, Your Honor.
Does that remain true today?
Yes, it does, Your Honor.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
To your knowledge, is Miss Curtis currently pregnant?
No.
Under the divorce here, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, Your Honor. We've both agreed on that.
Okay. And under the judgment, you and Miss Curtis have already divided up any property or debts between the two of you. Is that correct?
Yes, we have.
Okay. Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of Mr. Curtis. I did review the file. It appears that Ms. Curtis was properly served with the summons and complaint, that she did not file any kind of answer. A default was entered back on June 16th, and she was provided notice of that default along with notice of the date and time of today's hearing. Again, she has not appeared, so the court finds it would be appropriate to enter a default judgment of divorce. Mr. Curtis, I've signed that judgment, so your divorce is final as of today. Did you have any questions at all?
Thank you, Your Honor. That's all.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
All righty.
Good afternoon, Judge.
All right, good afternoon. Like your client is connecting right now.
Mr. Barros, can you turn your camera on? Thank you.
I'm trying to right now.
There you go.
All right, we'll go on the record. This is People versus Gabriel James Barros, case number 022761. The record should reflect Mr. Barros is present today by Zoom video. Counsel, if I could have you put your appearance on, please.
Thank you, Your Honor. Good afternoon, Your Honor. Attorney Jonathan Paul for Gabriel Barros. Good to see Your Honor and your staff this afternoon.
Thank you. We're on the record here today for a hearing on Mr. Barros' application to set aside a conviction that was entered back in July of 2002 in this case. I did have a chance to review the application as well as the file generally. It does appear, based on the notice from the Attorney General, that Mr. Barros would meet the technical requirements to have this application or this conviction set aside and the application granted. I know that Mr. Barros sought to have it set aside a few years ago, but I think changes in the law now have made this eligible. I also note that I am in receipt of his criminal history report as required from the Michigan State Police. Neither the Attorney General nor the prosecutor for Otsego County has appeared or otherwise objected to the application. All that being said, then what's left for the court's determination here today is whether Mr. Barros' post-conviction behavior and circumstances would warrant having the conviction set aside and whether it would be consistent with the public welfare to do so. Counsel, I usually have counsel just conduct some questioning of their client to establish those two elements. So,
yes,
Mr. Paul, are you prepared to do that today?
Yes, Your Honor. Mr. Barros, I'm going to ask you a couple of questions for the court. Please provide information for judge to assess your answers and he can make his decision. Are you ready?
Yes, sir.
Thank you. Mr. Barros, since the conviction in 2002, have you had any prior additional convictions at all?
No priors, no tickets.
Do you have any pending cases currently?
No, I don't.
And Mr. Barros, where do you currently reside?
Oregon, Albany, Oregon.
Are you currently married?
Yes.
Do you have any children?
I have 5 kids, but they're all grown except for my daughter. She's 6 years old.
What is your daughter's name?
My daughter's name is Sienna Barros Leon.
Who do you currently live with, Mr. Barros?
Excuse me?
Who do you currently live with?
Well, I currently live with my my wife and my daughter. Yeah, and then my mom comes over and watches my daughter when I'm at work.
And Mr. Barros, are you currently working?
Yes.
Has this conviction prevented you from achieving employment, a better employment?
Yes, it has, very much.
Thank you. Judge, any further inquiry?
Mr. Barros, can you just tell me a little bit more about what's gone on with you since this conviction was entered? How did you end up in Oregon? I just need a little more information just about your circumstances since this conviction 23 years ago.
Well, since then, I've been trying to look for my mother. I haven't seen her in 14, 15 years. Other than that, I've been connected back with her and moved to Oregon, to a different state, which I was trying to begin my life over again. Fortunately, with this conviction on my record, I couldn't move through any further except for fast food. As since then, I've been through a lot. I don't hang out anymore unless it's a family gathering with my family. I work very hard. I take care of my family and pay my bills on time. I've never been without a job for very long. I've had many. I would like to find something with helping the people job wise and give my family some stability. My wife works a lot and been through a lot with me. With this criminal record, I've been held back from making myself more responsibility person as far as in employment. I like working for the state of Oregon. Hopefully when its case is over with, I can go back and start again and continue my career with working for the state of Oregon and help my daughter with her autism and get a house for my family.
Okay. All right, thank you. So again, I'm familiar with the circumstances here. I've reviewed the application. I've heard what Mr. Barros has had to say here today. Number one, the court finds the fact that Mr. Barros has not had any further convictions or interactions with the justice system since 2022. So as I indicated earlier, 23 years. Mr. Barros has certainly demonstrated that he has moved on from this conviction and has led a law-abiding life since that time. So the court finds that his behavior and circumstances since the conviction would warrant having it set aside. I think in terms of Mr. Barros, your desire to pursue better employment opportunities, both to make more money and, as you indicated, to help people to a greater degree than you're able to now, potentially working with the state and so forth. I think that certainly are things that are consistent with the public welfare that as communities, and I'm sure your community there needs more people who want to do that kind of thing. And the fact that you're being prevented or held back from doing that by a conviction that's 23 years old, I think it would be consistent with the public welfare to allow you to pursue those opportunities, given the length of time between the conviction and now, and your lack of any other criminal history. So for those reasons, the court finds that those remaining two criteria have been met. The court will grant the application. I do have that proposed order, Mr. Paul, so the court will sign that order with today's date. Mr. Paul, anything else that I can address for your side today?
No, Your Honor. Thank you very much for your time. And to Miss O'Rourke, who I think is on your staff, she is super helpful during this case. So you're blessed to have her as part of your staff.
I can't agree with you more about that, for sure.
Thank you, Judge.
Okay, thank you. Mr. Barros, if you have any other questions about how to proceed from here, just get in touch with your attorney, and all parties are free to disconnect at this time.
Okay, thank you very much, Judge.
Thank you, Your Honor. Gabe, congratulations. I'll follow up in a bit with you, okay?
Thank you. You too. Thanks.
Realized that the order that I had in there was from 2016. I was like, ooh.
What's that?
I realized that the order that I had in there that I thought was good was from 2016.
Yeah.
I was like, ooh, I better get a new one.
Okay, we have council connected, so we'll go on the record in Carr versus Carr. This is file number 2419798. If I could have council put your appearances on, please.
Good afternoon, Judge Elliot Blumberg on behalf of Alma Carr, the plaintiff, who's appearing via Zoom from my office.
Thank you, Your Honor. Jason Thompson on behalf of defendant Scott Carr, who's with me in my office. Thank you.
Okay, we're set for a status conference in this case today, as well as Mr. Carr's motion to set aside the default. I did have a chance to read the motion. Mr. Thompson, did you have any argument you wanted to present?
No, we would rely on the written motion. Thank you, Your Honor.
Thank you. Mr. Blumberg, are you objecting to the motion?
We are, Judge. We've filed a response as well as a brief in opposition to the motion. My understanding that the court rules require the filing of a brief whenever there is a motion that raises questions of law. While I appreciate the motion, it doesn't give the court, doesn't establish for the court the authority to set aside the default. We all know what that is, obviously, but certainly the salient facts are is that Mr. Carr has been in default for about 10 months now. Has not participated in any meaningful way in this case, hasn't filed any financial information, the result of which was it cost my client a significant amount of money to get his pension valued, to determine what the value was. Based on that valuation, his military pension was significantly more valuable than my client's. And so we came up with what we perceive to be a fair and equitable division of the military pension. Again, there's been no showing of good cause, no showing of the existence of a meritorious defense, and even the affidavit signed by Mr. Carr doesn't really establish either of those requirements. I think that we were most recently before you attempting to get the judgment entered, and at that point, Mr. Carr indicated his desire to retain counsel. So it's a little late in the game. There hasn't been a proper showing of good cause or a meritorious defense. And ultimately, the division that we're asking the court to adopt in this judgment of divorce is both fair and equitable. So I would respectfully ask the court to deny the motion.
Thank you. Mr. Thompson, anything you wanted to state in response?
Just that, Your Honor, I appreciate counsel's remarks. I mean, Mr. Carr is not privy to any evaluation that's been performed. I don't believe the court is either, so I don't know how the court would be in a position to weigh in on the reasonableness of the judgment. Mr. Carr has, I would suggest, participated, certainly not correctly, but he has appeared multiple times for Zoom hearings, has negotiated much of the estate here in good faith and in a fair manner. The sticking point has been this retirement issue. I've heard counsel's representations about how they were divided. I would respectfully suggest the adversarial system would allow the court to have confidence that it is a fair and equitable division. Thank you.
Mr. Thompson, just to clarify what Mr. Carr's position is, I mean, is the pension division, the sense I got from your motion is that the pension is the real issue here?
It is.
I mean, are you looking to relitigate everything, or is it really just how this pension is divided up? That's
just the pension and retirement. I believe the motion indicates that my client did agree and that the division of the real estate and the cash assets were appropriate and fair. And yes, the remaining issue is Ms. Carr's retirement versus Mr. Carr's retirement and how that is valued and then divided.
Okay. All right. So looking at the law that applies in this case, it is a different court rule than it applies to defaults in civil cases generally. Under MCR 3.210B3 in domestic relations actions, the court can set aside a default for good cause. Under MCR 3.210B2D, the court can permit defaulted parties in divorce actions to engage in discovery, to file motions, to participate in court hearings, mediation, and other ADR procedure. In light of defaults, the court can impose limitations on that participation based on the circumstances of the default. And the court has to recognize that, different from typical civil actions, divorce cases are equitable actions where the court has an obligation to make sure that any property division and any default judgment that might result from a default is nevertheless equitable. Looking at the facts in this case, Mr. Carr did participate with Ms. Carr in terms of trying to reach agreements. So in that regard, he hasn't just not participated at all. He has appeared for court hearings on his own. So he wasn't defaulted because of his failure to participate with the court or some type of sanction for misconduct or so forth during the pendency of the case. I think it's significant that Mr. Carr is not trying to invalidate all the agreements that were made between him and Ms. Carr. He's just seeking to ensure that the retirement pension is being fairly divided. In my view, he's raising a very limited issue that the court would have to determine the fairness of anyway under 3.210B5E, even if the court were not to set aside the default. The court certainly would have to hear arguments before entering a judgment as to why, and make a determination as to whether or not and why plaintiff's proposed division of the pension was fair and equitable. So for all those reasons, the court finds there is good cause and it would be appropriate to set aside the default. But again, pursuant to court rule, the court is going to impose a limitation, and that is that the sole issue for further negotiation and resolution is the fair division of the retirement and pension of the parties. So the court will grant the motion as indicated here on the record. Mr. Thompson, if you would prepare an order that reflects that ruling of the court. And then in terms of scheduling, I mean, Mr. Thompson and Mr. Blumberg, do both of you want to have a chance to exchange some documents on this issue? Or how do you want to proceed, Mr. Blumberg, on behalf of the plaintiff?
Well, Judge, I fully appreciate and understand somewhat the court's ruling. My understanding of the court rule is that before the court sets aside a default, those fees that were incurred as a result or in reliance of the default has to be paid by the opposing party. I think that is a condition upon which the default to be set aside. And the reason why that's important is, again, as I pointed out, we've had to do all the discovery on our own. He has provided no documentation in regard to any assets, let alone his retirement. My client has expended, as I pointed out, a significant amount of money to get his retirement valued because he didn't provide us any of the information. So I would respectfully ask the court, if the court is going to set aside the default, I think my client's entitled to those fees incurred in reliance of the entry of the default.
Okay, if you want to submit a bill of costs and copy Mr. Thompson on that, then the court will take up that issue.
Thank you.
But in the interest of getting this resolved, I would like the parties I'd like to, as part of the status conference here, get some dates for going forward. So again, in terms of how to proceed, Mr. Blumberg, do you want to have a chance to have some negotiations with Mr. Thompson? Do you want the court to just set a mediation deadline today?
I'm certainly we're in a position to provide Mr. Thompson with the documentation that supports the division that we've requested. We'll share that documents, and he can certainly feel free to review them and make whatever determination. I don't know what other discovery really needs to be done. We'll provide what other information he needs.
Okay, Mr. Thompson?
Your Honor, in anticipation of today's hearing and this possible ruling, I did have my client prepare the financial information disclosure, so we're prepared to exchange that. So I think if we had a little bit of time to look at Mr. Blumberg's materials, he would certainly be able to look at ours. And then I think a mediation, 30 days out would be appropriate.
Okay, so I'm gonna have discovery remain open for 60 days. The court will refer this to community mediation to occur within that 60-day period. And then I'll set this for another status conference at that point. Mr. Blumberg, if you submit your billing to the court will enter an order without further hearing on that issue. And then if the parties are able to reach an agreement prior to that next status conference, I'd be happy to give a date. Otherwise, we'll see where we're at 60 days. We can always use that as a date to enter proofs as well.
Thank you.
Mr. Blumberg, anything further from your side today?
No, Judge, thank you.
Mr. Thompson.
Well, I guess, Your Honor, I'd like the ability to object depending on what bill of costs come in. I mean, if it's a motion for entry of default judgment, that's certainly contemplated. I believe Mr. Blumberg was describing all their discovery efforts, and I don't know if the court is ruling those are all costs incurred in reliance on of the default at this point, or if we would have an opportunity to object.
What I'd like to do is get the bill from Mr. Blumberg. I'll issue an order, but I would give you an opportunity, Mr. Thompson, to the extent that you have an objection to the court's order to file an objection to that and have a hearing. I think that would be fair.
All right, I will review that when it comes in. Thank you.
Right, but I guess my point is I'd like you to be able to see what the court intends to do, rather than have a hearing about things that may not be an issue.
I understand. I'll follow the court's procedure. Thank you.
All right. Okay, that's all for today. All parties are free to disconnect at this time. Thank you.
Thanks.